Hello, everybody. My name is Chad Doobay. I am an attorney in private practice at a law firm in Chicago. My principal field is in transactional law work, but I'm also active doing pro bono work for asylum seekers, immigrants, and refugees, primarily through the National Immigrant Justice Center. It's a Chicago-based advocacy organization that does direct services for immigrants and refugees, asylum seekers, and others, but also does policy advocacy at the state, local, and federal level, and has been active in this issue. I am thrilled to be on this panel and to hear from Mark about the wonderful vision that the Search School has shown, both with Mark and with Dean Brubaker. It really is an act of bravery to have the vision and to put it into place. So I'm thrilled about that. And also, clearly, I feel like I speak for all of us when we say how moved we are by the story of New and the bravery he's shown to this point, and that I'm just thrilled to see how his career turns out and to help cheer him along the way. To that end, I'm here to talk about the issues that remain with regard to licensure, full licensure for DACA eligible folks as they go from the steps that New has talked about, going into college, after taking the MCAT, getting accepted to and then matriculating into medical school, completing their residency, and as Mark mentioned, those are all things that we know aren't universally easy to do for anybody, but for DACA folks even. But there is a path now, now that DACA eligible folks have a social security number or have eligibility for a social security number. We now know and believe that those steps are all achievable. The next step is looking at the issue of state licensure. So I'll speak about that here. Licensing of professionals is, including medicine, is administered at the state level. And as a result, there are 50 different regimes for determining who is eligible to become a physician. There happens to be some degree of uniformity among states for key elements of that, passing the step tests and having other, going to certain medical schools and whatnot. But there are subtle differences, and those subtle differences matter for DACA eligible people. And we'll talk a bit about those. First, I'll talk a bit about current issues at state level that are relevant for us to look at the current lay of the land across the country. And then I'll talk about a field that's near and dear to my heart, the licensure of lawyers. And that area has been somewhat active recently with undocumented individuals and or DACA eligible individuals seeking licensure. And we'll talk just briefly about that. And then if we have time, I'll talk briefly about some constitutional considerations that might come into play down the road. The good news is that most states do not currently require an affirmative showing of citizenship status. You might ask why that is. The reason that seems to be evident is that medical licensure is administered at states at the departmental level and not necessarily at the court level. That difference is a little different for lawyers. State bars are certified normally by the highest courts. So for other professionals, the courts aren't really as actively involved on a routine basis, which also might explain why lawyers, the field of law, might be more active right in this issue right now, and we'll come to that in a moment. Also, more importantly, states have historically perceived citizenship issues to be the domain of the federal government. And so it's been unusual for states until recent years to become more taking on their own kind of perceived responsibility for administering and regulating federal immigration laws. Also, it really hasn't been an issue that's come up. That's, usually there's a policy when there's a problem. There haven't been a lot of physicians who were undocumented that were seeking licensure, or been able to navigate the system the Byzantine system that New described. But we're going to see that system is being successfully navigated by New and his colleagues, and will become a bigger issue. There are a handful of permissive states, and like Mark was saying, Illinois, as best as we can tell, is going to be a state where DACA physicians will be able to be licensed. There currently on the application is no citizenship requirement in Illinois, not even asked as a question. And until a full survey of all states is done and extensive interviews with all the different boards, it seems that most states actually comply with the same kind of format that Illinois puts forward. California as well, it's a state of interest. I know since New is from California, and a lot of activities happening in California with DACA eligible students. As best as we can tell, the Medical Board of California has indicated that all they are interested in is students having the requisite training, having gone to residency, and have work authorization, which we know DACA folks do have. A couple other states to talk about. Tennessee, you might be interested to know. It is interesting because it does speak to citizenship in their application, but its language predates a lot of the kind of recent fury related to immigration issues. Their application reads, one must submit proof of their citizenship in the United States or Canada, interestingly, or evidence of being legally entitled to live and work in the United States. So that language is interesting because it's not keyed toward necessarily undocumented folks. People that have DACA status actually are legally entitled to live and work in the United States. So that state won't necessarily be a problem. There are, however, a handful of restrictive states and there could be others, but a few that I wanted to highlight come about after the wave of anti-immigrant legislation at the state level following 2011. You might recall a lot of activity in Arizona in particular. It's in southern states, and I'll talk briefly about those here. Arizona has a form that we were just talking about here this morning that requires all newly applying physicians to complete this 2-page form where one must declare their citizenship, immigration status, and it's a very detailed form that requires you to not only declare what status you have, but also to provide documentation to support that. It's unclear how this will play out in the future. Alabama and Georgia also have similar requirements, but interestingly, they also require existing license holders who are renewing to also complete a similar form, declaring their status and providing documentation related to this. This has been, the one in Georgia in particular, which is of course interest since we are standing in Georgia right now, has been receiving a good amount of attention in the media because the form was so complicated and such a surprise to most physicians who have been practicing in Georgia for decades to have to conjure up images of their passports or birth certificates, that a lot of people failed to properly apply for this, to put in the material that was needed. And the staffing for reviewing all of this was, people were having difficulty matching up the requirements to what was being provided. There were a handful of people that were protesting the requirement by sending in pictures of their pets. I mentioned that not to be totally in humor, but also just to give you an idea of what could come if future states pick up this type of format and decide to follow suit. At one point, about 1,300 doctors were technically unlicensed because of the delays in reviewing these applications. So you can see the impact that might cause. Having physicians unlicensed makes them ineligible for reimbursement from the federal government. So that has an impact on everybody. And but all this in an effort to meet this new wave of state laws. Another state, kind of an exceptional state, is New York, interestingly. New York currently only allows citizens and LPRs, legal permanent residents or green card holders, to obtain professional licensure. There's been a lot of activity at the court level in New York to broaden that group. But unlike Arizona, Alabama, and Georgia, the move has been away from these strict requirements in New York. And they're kind of older requirements that are kind of being chipped away at. Now the motivation though for Arizona, Alabama, and Georgia seems to be squarely and explicitly actually in the case of Arizona, the new excitement about the 1996 Personal Responsibility and Work Opportunity Reconciliation Act. You might recall that as the Welfare Reform Act in the mid-90s. Of course, this has been around for a long time, but recent attention at the state level by people concerned about public benefit access brought about a whole wave of restrictions at the state level. What the law does is it prohibits certain categories of individuals from obtaining what are called public benefits. Benefits are defined to include, and this is a quote, any grant, contract, loan, professional license, or commercial license provided by any agency of a state or local government or by appropriated funds of a state or local government. So it would be read into this then that a state board that's providing medical licensure would be restricted from providing this benefit, which is recognition of medical licensure at the state level. The benefits are only to be provided underneath this 1996 law to a number of individuals who include qualified aliens, citizens, qualified aliens, which is a defined term there, and non-immigrant aliens. So the closest look for who DACA eligible people would fit into would be this group of non-immigrant aliens. But what is interesting about that term DACA, non-immigrant aliens, and recall this was defined in a law in 1996 before DACA was even considered a possibility, is that DACA eligible folks would not technically be read into this group of non-immigrant aliens. So would be ineligible for being considered into this group. What's interesting though is that certain visa holders would be qualified underneath this. So someone with a J1 visa or an H1B visa would be read into this as being eligible for licensure for this public benefit by having been having that visa. But because of the unique situation of DACA status people is that they have authorization to work but no visa. And so that puts them kind of in this peculiar situation of not being technically eligible. There's also this idea too of lawful presence in the United States and the benefits that come with being lawfully present. So we have the Department of Homeland Security making it clear, and this is after the wave of concern about access to driver's licenses, that DACA eligible people are in fact lawfully present, or they are not unlawfully present rather. But we have the Department of Justice at the same time arguing that they are not eligible for being considered non-immigrant aliens. So there is clearly a lot of confusion at the different levels there. I'll go into the issue of law licensure that's come up. And there's a couple states that have been a little bit active about this. And it's a useful analogy because professional licensure of any profession speaks to how different professions different boards might make outcomes on this. First case I'll talk about is a case of Sergio Garcia. And this is Mr. Garcia went to law school in California, passed the California bar, which if anyone knows anyone that's passed the California bar, it's not easy to do. And the California bar recommended him for approval based on his character. Garcia unfortunately does not qualify for DACA because he is too old for that. Of note though is that he applied for residency based on the status of his family members, and his application has been pending for 19 years. His family's from Mexico, and based on the grid set up by the federal government, he's not expected to have his official approval until 2019 because of the queue that's in place for family members connected to Mexico. Sadly, in recent California Supreme Court oral arguments, a final decision hasn't been made, but the judges, and even the most progressive judges on the court, demonstrated that they were not inclined to grant approval to Mr. Garcia based on the 1996 welfare reform law and the restrictions that they felt trumped his case there. But it is important to note that actually Judge Baxter, who was considered one of the more conservative justices, kind of wondered aloud during the oral arguments whether the state had properly taken advantage of exceptions to the welfare law. And the exception is that states can affirmatively add categories of beneficiaries if done by state legislation. So if the state of California were to pass a law saying DACA eligible or undocumented people can become licensed in the state, affirmatively stating that, then they could be considered acceptable in the realm of receiving a public benefit under the welfare law. So within days, legislators in California put that together, passed it by an enormous margin. It was signed into law recently. So the good news for Mr. Garcia is that even with the case not decided, is that he is able to get a law license. Unfortunately, because he does not have DACA status or other status, he's not able to legally work. So that situation is still important to watch, and also important to consider if the Court of California comes out with a decision, which is expected in any day. If that court decision will be looked at very closely by the rest of the country. I'll talk briefly too about the case of in Florida, another case of a law student or someone who's gone through law school and is trying to get approval for a law license, Jose Godinez Sampiero. He's a 26-year-old who was brought here when he was 9 by his parents, went to law school, passed the Florida bar, including the character and fitness part. The question was raised in 2011 when the Florida Board of Bar Examiners received his application, and at the time, in 2011, he was undocumented, and the Florida Bar wanted to know if they requested an opinion of the court saying, can we give him a license? Are we allowed to do this? But his case is interesting because he received DACA status in the interim. So he does have DACA status, and the question is whether or not he'll be able to get a law license. The Florida State Supreme Court said in April of this year that undocumented immigrants cannot be admitted to the bar, but in kind of a strange situation, they didn't actually state that he could not be eligible for it. And they're still waiting to find out what the Florida Bar will actually do, if they will give him status. The Florida Bar seemed to, the Florida court seemed to be trying to avoid making a statement specifically to his case or to DACA people generally. Interestingly, the Department of Justice put in a friend of the court brief in support of denying his licensure based on the 1996 welfare reform law, and saying that DACA status had no impact, that he would still be not qualified as a non-immigrant. And it seems both in California and in Florida that both groups are trying to, we're hoping, I think, that a comprehensive immigration reform would solve this problem and take them out of this limbo of having to make a decision and with all of these weird exceptions based on having status, authorization, but not having a visa. So these issues can be addressed as we're seeing in Florida and California, either through comprehensive immigration reform, where we just remedy and change the requirements of the 1996 law, or Florida, other states could affirmatively make statements, pass laws that would affirmatively grant authorization, or like I said, DACA holders could be put into a special category, for example, into the 1996 law as an added beneficiary. I'll talk I'm running out of time, so I'll just talk very briefly about the judicial considerations. If this ever were to get to a circuit court level for adjudication or determination, it'll be interesting to note that Supreme Court precedents treats the field of alienage as a suspect field, and so anyone who is discriminated against based on their alienage, that is their lack of citizenship in any form, in a broad sense at the Supreme Court level, any state restriction on that is subject to strict scrutiny and will almost always fail. But subsets of that have not really been tested at the Supreme Court level. That is green card holders versus non-immigrant aliens, J-1 visa holders or H-1B visa holders. So there's currently a split. The Fifth Circuit has looked at this and treated non-immigrants differently than aliens generally, and the Second Circuit has said that's not in line with Supreme Court jurisprudence and unacceptable and wrong. No one, of course, has looked at undocumented people aside from non-immigrants or DACA holders there either. So if a case does come up, most people who look at constitutional law would consider the broad umbrella created by the Supreme Court of all aliens underneath immigration law, all non-citizens, as being the suspect class and not subgroups of that. But just keep that in the back of your mind as this kind of goes through the system. and people look at these things here.